The trial chamber 5B's decision appeared to be a formality. After all, sign had shown that the case facing the president was just nearing its end. The decision was welcomed across the political divide, with many expressing hope that the president would direct his energies to governance and taming corruption that has been the biggest wound in his Jubilee administration. But opinion is divided among legal and political analysts on whether the president is really off the hook.
He's not 100% off the hook, because certain things were dealt with by the chamber, notably that those who interfered with witnesses, either through compromise or elimination, will still have to be pursued. And if, for whatever reason, that will fall at the doorstep of Uhuru Kenyatta, then I think ICC judges would move so swiftly to prefer new charges against the president.
The president can concentrate on the mandate the Kenyans gave to him. It is a good relief for the president, and it is a good relief for Kenyans, because now we have somebody we can rely on, somebody we can put to account, because he is there, unlike the other time when he was here and was busy defending his case.
In the decision by the judges yesterday, they indicated that Bensouda was free to bring up fresh charges against the president in future or to prosecute him on the same charges once she has evidence that would sustain trial. But Okello and Omari appeared to write off any prospects of a new case.
It will be a very new trial. Therefore, the rigors and provisions and procedures that entail in criminal processes must start afresh. She must start where Ocampo started.
It does not go back to the pretrial chamber. You remember the pretrial chamber had already given a nod for Kenyan cases to proceed to the trial chamber. So that what Bensouda will definitely do, which I doubt whether she will, is to only rely on the prevailing circumstances.
What Kenyans will be keenly observing, though, is whether Bensouda will appeal the decision by the trial judges that failed to refer Kenya to the Assembly of State Parties over non-cooperation, granted that she has already been given the go-ahead to appeal. Does she stand any chance if she takes that route?
Well, I think she has chances with the Court of Appeal. There are many cases that have gone to the Court of Appeal at the ICC. And you remember, Court of Appeal has 5 judges. The trial court has 3 judges. So whatever, based on merit, that the trial court has looked into and reached a decision can be overturned by the Court of Appeal.
I don't think that she has any chance of succeeding to convince the judges. But as I've said, if you look at the ruling and the reasons given as to why the judges arrived at that decision, they are well-reasoned ruling. It is a well-balanced ruling, and the decision is as per the facts that were presented and the provisions of the law.
If Bensouda was to have her way and the appellate judges at the ICC rule in her favor, what would it mean for Kenya?
Kenya will always use its African numerical strength.
Because that is a political court. It is a lobbying court. It's not a criminal court. It's not a court of law. Kenya has developed Uhuru and the African states control the majority in terms of membership.
President Uhuru Kenyatta has always insisted that the investigations leading to his indictment by the ICC were shambolic and unfair, and that his name had been maligned. So, can he sue?
Uhuru Kenyatta will still have to wait for whatever process that is still pending, including Assembly of State Parties intervention. But if we come to a level that the case will be dead, or rather dodo dead, then Uhuru Kenyatta can now turn around and under defamation, which I think can as well be handled, put OTP on its toes.
Politically,